Hello, everyone. Okay, this is Wayfarer's opposition to Blake Lively's motion for spoliation sanctions. There is a separate one, which is almost as long as this, on file for Jen Abel's opposition to Stephanie Jones's motion for spoliation sanctions, which is almost the same as Blake Lively's. However, I anticipate the response is going to be, there are going to be differences. So I'm going to do that as a separate video because these are 30-page long documents. So I'm going to do that as a separate video. And then I will do another one later on or tomorrow, covering the exhibits that are unsealed. Not all of them are unsealed, but there are some that are. So I will cover them if there's something there to be covered. Okay, so Wayfarer's opposition to Blake Lively's absolutely ridiculous. I'm just going to start there and get some outrage out of my system. This is ridiculous request for sanctions for these reasons. Okay. My voice may come and go. I've woken up. I've already done one video this morning, and it's already crackly. So I am gonna try and get through this as best possible, and try not to clear my throat as much. Okay, plaintiff Blake Lively's sanctions motion should be denied. Lively seeks the most severe sanctions available under Rule 37E, including an adverse inference that an August 2024 crisis management strategy was not only planned but executed, and a preclusion order barring defendants from presenting any evidence refuting Lively's claim that they executed on the plan to manipulate the internet to defame Lively and derail her career, for which she is now seeking a mere $300 million in damages. Lively's showing falls woefully short of the harsh standard for sanctions under Rule 37E2, or even the lesser sanctions available under Rule 37E1. So straight out the bat, we have snark. I have skimmed this motion, by the way, this opposition, and it is brilliant and takes a lot of digs at Lively, which are just great. Boiled down to its essence, the motion asserts that some defendants may have used Signal to discuss topics relevant to this litigation prior to the December 20th filing of Lively's complaint without disabling the auto-delete feature. Lively assumes and asks the court to assume that all 8 defendants deleted messages that might have further shown that defendants executed on a crisis management strategy that turned the internet against Lively in August 2024, at the time the film It Ends With Us was released. The mere assumption that some or all defendants may have deleted relevant evidence, even intentionally, is not enough to justify sanctions that would devastate the defense of 8 defendants. That's a strong argument. The motion's first flaw is that Lively seeks blanket sanctions against all defendants without distinction. Rule 37E sanctions are personal and cannot be awarded against a group of 8 without proof that each independently spoliated evidence. Lively fails to show that any message evidencing the implementation of a smear campaign was deleted by a particular defendant, or even that all defendants used Signal to communicate about Lively prior to the filing of her complaint. Rather, Lively indiscriminately seeks sanctions against all 8 defendants. Plaintiff admits that it is unclear whether all defendants used Signal prior to December 20th, 2024. The allegation that all defendants executed a crisis management strategy to manipulate the internet, Lively refers to this as a digital campaign, is based solely on the supposition that negative publicity about Lively went viral in August 2024, and thus defendants must have been the cause. In fact, Lively fails to identify specific communications that might demonstrate the implementation of the digital campaign. She only speculates that such evidence may or must have existed and been automatically deleted. Lively stubbornly refuses to acknowledge or take any responsibility for her own conduct, which was the impetus for the public backlash that spiraled out of control when the film was released in August 2024. Lively also fails to make the critical threshold showing for application of Rule 37E, namely that any defendant anticipated litigation over a smear campaign. The purported subject of the allegedly deleted communications and thus had a duty to preserve such evidence prior to the filing of Lively's December 20th, 2024 complaint. Lively's claims fall into two categories. One, claims relating to the alleged sexual harassment and gender discrimination by certain Wayfarer defendants occurring between May 15th and June 14th, 2023. And two, claims relating to an alleged digital or smear campaign that allegedly began in August 2024. The signal messages that are subject of plaintiff's motion relate to the digital or smear campaign allegedly conceived in August 2024, not Lively's sexual harassment claims, which arose between May 15th and June 14th, 2023. Plaintiff does not even attempt to show that any party contemplated litigation over a public relations strategy or digital campaign when unspecified signal messages allegedly were deleted by any defendant. Plaintiff merely points to a November 9, 2023 demand letter relating to the objections she raised in 2023 and defendant's discovery response, which confirmed that in November 2023 they anticipated litigation in connection with the shooting of the film in May and June 2023. Lively fails to demonstrate that defendants reasonably foresaw litigation in which the August to December 2024 signal chats might be relevant and thus fails to establish a duty to preserve those messages. Lively next fails to show prejudice caused by the acts of any defendant, a predicate for Rule 37E sanctions. In fact, plaintiff fails to show prejudice at all. Lively contends that severe prejudice is obvious because deleted signal messages may have further shown defendants' execution of the digital campaign, thereby impairing Miss Lively's ability to fully prosecute her claims and rebut the defence that the Wallace defendants decided, after being retained, that no proactive digital campaign work was required given organic online sentiment. Yet on the very first page of her motion, plaintiff admits that she was not prejudiced by the deletion of signal threads by noting that despite defendants' alleged efforts to cover their tracks, there is substantial evidence that the retaliatory campaign was in fact implemented as planned. Lively has also produced multiple expert reports which rely on the evidence she provided to opine, albeit erroneously, on the execution of the digital campaign. Since she admittedly has substantial evidence that the digital campaign was implemented, Lively cannot establish prejudice from the purported denial of further evidence, which may be subject to exclusion as cumulative. Absent a showing of prejudice, plaintiff is not entitled to sanctions under Rule 37E. Lively thus fails to establish her right to sanctions under Rule 37E(1), which, upon a showing of prejudice, are limited to those sufficient to cure the prejudice she has not shown. But Lively does not seek sanctions under subsection E1. She seeks the more severe sanctions of an adverse inference and preclusion available only under Rule 37E2. Failing to meet her burden under 37E1, Lively is not entitled to sanctions under 37E2. Even assuming she met her burden under 37E1, Lively fails to establish that any defendant acted with the intent to deprive her of specific evidence for use in this litigation, a predicate for the onerous sanctions available under subsection E2 only. As elaborated below, conjecture and speculation are insufficient to justify sanctions under Rule 37E, much less the severe sanctions of an adverse inference and presumption that damaging evidence existed and was deleted. In fact, this is only one of multiple sanctions motions in which Lively, implicitly conceding that the evidence adduced in discovery will not support her claims, seeks to exclude evidence crucial to the defense. And we have a footnote. Which I love this footnote actually. Plaintiff devotes much time to arguing that defendants were too slow in producing documents or otherwise engaged in efforts to obstruct discovery. Defendants deny these accusations. Most importantly, perceived shortcomings in defendants' discovery efforts are not relevant to a Rule 37E analysis, as the court cannot impose sanctions for spoliation of ESI pursuant to its inherent powers. Okay. Crippling the defense of 8 defendants to avoid having to prove claims with admissible evidence is not a proper purpose of Rule 37E. And that is what she's doing. She is effectively trying to clip Wayfarer's wings when it comes to trial time. She wants, effectively the judge to say, yeah, what she's saying is true. This evidence did exist and Wayfarer deleted it. But also, she wanted Wayfarer to be silenced from speaking about what, their kind of testimony and defending themselves. Okay. Plaintiff asserts claims for sexual harassment and retaliation under FEHA and Title VII, as well as defamation and other reputational harm against defendants Jamie Heath, Justin Baldoni, Steve Sarowitz, Wayfarer Studios, It Ends With Us movie, collectively the Wayfarer defendants. Plaintiff also complains that Wayfarer's public relations / crisis management team, Jen Abel, Melissa Nathan, and TAG, collectively the PR defendants, were involved in an alleged digital campaign that manipulated negative content against Lively on the internet. The relevant facts are summarized below. And this is where it's about to get good. A. The film It Ends With Us and Lively's complaints about misconduct on the set. The film began shooting in New Jersey and New York on May 15, 2023. Phase 1 ended on June 14, 2023 due to the Writers Guild and SAG strikes. During Phase 1, Lively complained about purported mistreatment on the set by Baldoni and Heath, including alleged conduct that made her uncomfortable. Her complaints ranged from wardrobe and scheduling issues to Baldoni's statements that she looked hot or sexy in a costume designed for an intimate scene between Baldoni's and Lively's characters. And Heath showing her a video of his wife after the birth of his daughter in connection with the filming of a birthing scene. Lively did not file a formal complaint but voiced concerns to Baldoni, Heath, and others, including the film's distributor, Sony, no later than June 1st, 2023. B. The protections and resolution of Lively's complaints. During the strike-related pause in filming on November 9, 2023, the Wayfarer defendants received a letter from Lively's lawyer, Lindsay Strasberg, demanding that Wayfarer agree to a 17-point list of protections as a condition for Lively's return to complete the film. The letter stated that if the production is unwilling to accept or uphold these protections, our client is prepared to pursue her full legal rights and remedies. Under extreme financial pressure to complete the film and pressure from Sony, the film's co-investor, Wayfarer agreed to the protections. The Wayfarer defendants understood that their agreement to the protections resolved the issues that had arisen during Phase 1 and eliminated the threat of potential litigation. Filming resumed on January 5, 2024, following an extremely tense all-hands meeting on January 4, 2024, in which Lively's husband, Ryan Reynolds, spent hours berating the Wayfarer defendants for their conduct in Phase 1. After returning to the set, Lively did not assert any further complaints. Filming, which began on January 5th, wrapped up on February 9th, 2024. There is no evidence or even allegation that the Wayfarer parties failed to uphold the protections during the second phase of filming. In fact, on January 14th, 2024, redacted. The PR defendants were not parties to the protections, did not attend the January 4th all-hands meeting, for which I'm sure they are grateful. Attendees at the meeting included Mr. Baldoni, Mr. Heath, Miss Gianetti, Alex Sachs, Todd Black, Miss Lively, and Miss Lively's husband, Ryan Reynolds. And they did not have any contact with Lively about her complaints of misconduct in Phase 1. C. Lively hijacks control of the film from the Wayfarer defendants. During the second phase of production, Lively moved to seize control of the production. Among other things, she wrested control over editing, post-production, and marketing from Baldoni and Wayfarer. Ultimately, Lively gained control over the entire post-production process. Redacted. Lively also demanded that Baldoni's film by credit be removed. Redacted. And then there's more redactions. Lively accomplished her takeover through threats that if her demands were not met, she would not participate in marketing the film, even though she was contractually obligated to do so. Not content with usurping Baldoni's role as director and excluding him from the marketing of the film he developed, financed, directed, and starred in, Lively then sidelined, indeed banished, Baldoni from the premiere, refusing to be photographed with him and demanding that he and his guests be hidden from sight and shunning Baldoni and his guests into another screening room. Baldoni was also barred from appearing with Lively in publicity photos or promotional appearances. Lively very publicly unfollowed Baldoni on social media. D. The public relations response to Lively's attacks and the surge in chatter over discord on the film's set. By the time of the film's August 6, 2024 premiere, rumors of discord on the film set were already swirling on social media and in the press. These rumors were fueled by redacted. Lively's redacted. Lively's unfollowing of Baldoni on social media and Lively's insistence that Baldoni be stripped of the credit filmed by Justin Baldoni on the movie he developed, sold, directed, and starred in. Lively was also redacted. This This decision was particularly tone deaf. So whatever decision they're talking about now, that is redacted. This decision was particularly tone deaf given the role of alcohol abuse in domestic violence cases. Nevertheless, Lively used alcoholic beverages used in her Betty Boo's alcohol products such as Rile You Wait and It Ends With Buzz at promotional events. The public backlash was immediate and unforgiving. And then they point to an article from the New York Times. What It Ends With Us says about the Blake Lively brand. Given the circumstances and Lively's affirmatively hostile conduct, the Wayfarer parties were understandably concerned about a potential onslaught of negative publicity from Lively. On July 25th, 2024, the Wayfarer parties contacted crisis communication specialist Melissa Nathan and her company TAG to defuse and defend against Lively's anticipated assault and protect the film and Baldoni's professional reputation as a producer and director. The Wayfarer defendants also retained Jed Wallace to provide digital monitoring services. Nathan, who was first engaged as a crisis manager on August 2nd, 2024, 9 months after the Strasbourg letter, so that's the return to productions letter, and over a year after the alleged acts Lively now claims as harassment, had no involvement with the film or the Wayfarer defendants during filming, did not receive a copy of the Strasbourg letter, and had no contemporaneous knowledge of Lively's litigation threats. However, Heath provided Abel with a copy of the Strasbourg letter and the 17-point list of protections on November 10th, 2023. On August 2nd, 2024, the crisis management / public relations team circulated a scenario planning document with a proposed strategy to counter against negative press and Lively's efforts to disparage Baldoni and Heath as the film's director and producer, respectively, tamp down the growing chatter on the internet's rumor mill, and handle the response should Lively and her team make her grievances public. Lively defines this defensive measure as the launch of a retaliatory smear campaign and contends that in the weeks and months that followed, the Wayfarer parties engaged in a sophisticated, coordinated, and well-financed retaliation plan. In fact, the Wayfarer defendants did nothing other than exercise their right to defend against Lively's attacks and the tidal wave of negative publicity triggered by Lively's conduct. Lively implicitly concedes that the goal of the Wayfarer defendants' public relations effort was not retaliation for some protected activity, but to defend Baldoni and his reputation. The strategy described in the scenario planning document was never implemented. Anti-Lively, pro-Baldoni sentiment went viral organically. The negative publicity spiked on the eve of the August 6th premiere and August 9th, 2024 release date. Plaintiff's own timeline indicates that defendants could not have been the masterminds behind the spike in the negative publicity. Plaintiff points to spikes in negative internet traffic on August 8th and 14th, 2024. Okay. Wallace was recommended to defendants on August 8th and engaged on August 9th. The first spike in negative digital coverage began on August 8th before Wallace, the alleged digital wizard, was retained, and only one day after he was referred by Nathan. Even looking at the August 14th spike, plaintiff does not offer any explanation about how the PR defendants and Wallace were able to turn the entire internet against Lively in less than 2 days. These facts undermine Lively's presumption that defendants manipulated a spike in the already burgeoning negative sentiment targeted at Lively. E. The use of Signal by some defendants. After the crisis management team was brought on board in August 2024, and prior to plaintiff's filing of her claim on December 20th, 2024, certain defendants used Signal chats to communicate. Signal is a commonly used app which provides enhanced security features. The security protections Signal provides made Signal the preferred and primary means of communication between Nathan, the crisis manager, and Jed Wallace, who operated in a highly charged media environment. Other defendants used Signal on limited occasions. Jamie Heath communicated at least twice on Signal during this period. Sarowitz, Baldoni, and Abel did not use Signal at all during the pre-litigation period to communicate about Lively. However, to the extent Signal was used, the participants had Signal set on its auto-delete feature. Defendants therefore have no Signal communications from the pre-litigation period. However, defendants also use traditional platforms such as text messages to communicate about Lively. These messages have been produced, and some of these messages may be included in the substantial evidence Lively claims exists. I've got a footnote. For instance, Lively cites the June 2024 message in which Abel discusses whether to recommend Brian Friedman, and in August 2024, Katie Case indicated they were getting ready to go to war. Plaintiff filed her CRD complaint on December 20th, 2024, and on the same day sent a cease and desist letter advising the parties of a litigation hold. Mr. Friedman, although he had been introduced to defendants in August 2024, was not retained until December 24th, 2024. The engagement letter cautioned defendants to preserve documents. Shortly thereafter, defendants switched off the auto-delete feature. Non-privileged Signal communications after December 20th, 2024 have been produced. Okay, so part 3. Plaintiff fails to meet her burden to show that she is entitled to sanctions under Rule 37E(1). And we have a footnote. The Second Circuit has not decided whether a preponderance of evidence or clear and convincing standard of proof on spoliation claims or on what issues. It is the movement's burden to establish by clear and convincing evidence that the non-moving party acted with intent to deprive him of the spoliated evidence. The party requesting an adverse inference bears the burden to show by clear and convincing evidence that the alleged spoliator acted with intent to deprive the movement of the information for use in the litigation. Moving party on spoliation motion must prove bad faith and intent to deprive by clear and convincing evidence. Just see if that continues over. Yes, as shown below, plaintiff's motion fails to meet even the lesser preponderance standard. Spoliation is the destruction or significant alteration of evidence or the failure to preserve property for another's use as evidence in pending or reasonably foreseeable litigation. Federal Rules of Civil Procedure 37E governs spoliation of electronically stored information. Rule 37E sanctions are entrusted to the court's discretion. A party seeking sanctions for spoliation has the burden to establish 1. That the party having control over the evidence had an obligation to preserve it at the time it was destroyed. 2. That the evidence was destroyed with a culpable state of mind. And 3. The destroyed evidence was relevant to the party's claim or defense such that a reasonable trier of fact could find that it would support that claim or defense. There are two levels of sanctions under Rule 37E. Sanctions under Rule 37E1 are available upon a showing of prejudice and are limited to measures no greater than necessary to cure the prejudice. The court is not required to adopt measures to cure every possible prejudicial effect. Under Rule 37E1, a court may permit the prejudiced party to present evidence to the jury concerning the loss and likely relevance of the information and instruct the jury that it may consider that evidence along with all the other evidence in the case in making its decision. More severe sanctions, including an adverse inference, presumption, and terminating sanctions, are available only under Rule 37E2, which requires an additional showing that the spoliating party deleted or destroyed evidence with the intent to deprive the non-spoliating party of its use in the litigation. As noted, plaintiff is seeking draconian sanctions available only under 37E2. Including an adverse inference that defendants intentionally deleted and failed to preserve relevant evidence when they had an obligation to do so, and that the destroyed evidence would have further shown defendants' execution of the digital campaign, and an order precluding defendants from arguing that they did not execute their digital campaign and they openly planned to do. Imposition of such sanctions would be tantamount to a dispositive ruling on plaintiffs' retaliation and defamation claims. So what that means is that they're saying, well, if you give her what she wants, you're effectively making a ruling, a judgment on her claims, which is a good argument, very good argument. A. Plaintiff fails to establish sanctionable conduct by any particular defendant. And I did like this argument. As a preliminary matter, Rule 37E sanctions are personal and the destruction of documents by one party cannot give rise to a spoliation sanction against another party. Plaintiff does not identify which of the 8 defendants may have used, signal, and deleted specific items of relevant evidence. Plaintiff merely asserts in the most conclusory fashion that there is no dispute that each of the defendants used Signal as an ephemeral messaging platform to discuss issues related to this litigation, and that in August 2024, all defendants, including Nathan, decided to go to war. There may be no dispute that some defendants use Signal. There is certainly a dispute over whether all defendants use Signal and whether any defendant deleted messages evidencing the execution of a planned digital campaign. In fact, there is no evidence that most defendants used Signal prior to December 20th, 2024. Much less used Signal to communicate about this litigation or deleted relevant evidence. Plaintiff concedes that the pre-litigation Signal threads relating to Lively were used primarily by Nathan and Wallace, and admits that it's unclear whether Mr. Baldoni and Mr. Sarowitz were separately using Signal prior to December 20th, 2024. Sarowitz, however, did not believe he used Signal to communicate about the film prior to December 20th, 2024. Baldoni also did not use Signal prior to December 20th, 2024 to communicate about Lively, but only used it in connection with a men's support group unrelated to Lively or this action. Heath downloaded Signal in August 24th and briefly connected with Wallace. There is no evidence that Heath's handful of messages, evidence, or even reference the implementation of a plan to manipulate the internet to ramp up negative publicity about Lively. Abel did not use Signal prior to Lively's filing of her complaint except for communications relating to another very high-profile client unrelated to this action. In sum, plaintiff fails to show that particular defendant used Signal during the pre-litigation period, much less deleted evidence that defendant's public relations strategies outlined in the scenario planning document were put in motion. Yet the blanket sanctions sought by plaintiff would effectively strip all 8 defendants of any ability to defend against her retaliation and defamation claims. Plaintiff is not entitled to blanket sanctions against all 8 defendants without specifically identifying what evidence each defendant allegedly possessed and deleted. B. Plaintiff fails to show that defendants had a duty to preserve allegedly deleted evidence. To even establish that Rule 37E even applies, a party seeking spoliation sanctions must show that the destroying party had an obligation to preserve the evidence at the time it was destroyed. The duty to preserve evidence most commonly arises when suit has already been filed, providing the party responsible for the destruction with express notice, but also on occasion in other circumstances, as, for example, when a party should have known that the evidence may be relevant to future litigation. Okay. Plaintiff contends that Strasbourg's November 9th, 2023 demand letter placed the Wayfarer defendants on notice of potential litigation and that the evidence was relevant to litigation. Plaintiff also cites defendants' interrogatory responses which acknowledge that the Wayfarer defendants recognized the possibility of litigation relating to the shooting of the film in or around mid-August 2024. In other words, the only litigation that could have been anticipated in August 2024 involved Lively's objections in Phase 1. However, Lively's motion is based on the premise that allegedly deleted Signal threads may have been relevant to the execution of the digital campaign, not Lively's claims of harassment or discrimination during Phase 1 of shooting. Plaintiff provides no support for the allegation that any party contemplated litigation over a public relations strategy or digital campaign when Signal messages were deleted. And naturally, Lively does not explain how any defendant could not have reasonably foreseen litigation in November 2023 over a retaliatory smear campaign that did not happen until August 2024. In fact, even the threat of litigation over Lively's harassment allegations dissipated when the Wayfarer defendants agreed to the protections Lively and Strasbourg's express condition for avoiding litigation. Really strong argument. She's alleging that they've deleted evidence of a retaliatory smear campaign, and they should have known that there was going to be litigation for the retaliatory smear campaign, but before the smear campaign had even happened. Finally, Lively identifies Nathan as the most frequent user of Signal. Nathan was retained in August 2024 as a crisis manager to handle the growing public relations crisis spurred by Lively's efforts to seize control of the film and sideline Baldoni and Wayfarer. There is no evidence that prior to December 20th, 2024, Nathan had reason to anticipate litigation involving her crisis management activities on behalf of the Wayfarer parties. In fact, there is no evidence whatsoever that Nathan could have reasonably foreseen even litigation relating to Lively's earlier objections. Nathan was not involved with Wayfarer in 2023, and there is no evidence that she knew of Strasbourg's November 9th, 2023 demand letter, or even the nature of Lively's complaints. Plaintiff cites not a whit of evidence that the war was in any way linked to Lively's discrimination claims. In other words, there is no evidence that Nathan and Tag could have reasonably foreseen litigation giving rise to a duty to preserve evidence when their signal messages were deleted. C. Plaintiff fails to show that the allegedly destroyed documents existed. Rule 37E requires a showing that evidence existed and was destroyed. An assumption or speculation that allegedly deleted relevant evidence existed is not sufficient. I'm just going past the legal citations because it's there's a lot and add a lot of time. Plaintiff glosses over this technicality, asking this court to assume that defendants deleted signal chats, evidencing that they executed the public relations crisis management strategy. Such assumptions based solely on speculation are insufficient to justify Rule 37E sanctions. Plaintiff disingenuously cites Barbara, where this court granted Rule 37E1 sanctions. There, it was undisputed that plaintiff destroyed specific evidence showing when plaintiff discovered the alleged infringement at the heart of his claim. As a footnote, plaintiff fails to note that the court imposed the lesser sanctions available under subsection E1 only, even though it found that the plaintiff deliberately destroyed highly relevant evidence. The court denied the more severe sanctions available under subsection E2 because the moving party failed to show that the plaintiff acted with the intent to deprive the defendant of the evidence for use in the litigation. Although it was unclear precisely what documents were lost, it was not disputed that the deletions included documents recording his discovery of the alleged infringement, including his initial correspondence regarding that discovery, which established not only the time of his knowledge, but that he anticipated litigation at the time he deleted the documents. Plaintiff's destruction of this evidence prejudiced the defendant's ability to prove a statute of limitations defense. These facts are in sharp contrast to this case where plaintiff fails to identify a single item of relevant evidence that was destroyed by any defendant. D. Plaintiff fails to show prejudice. Showing a prejudice is crucial to the spoliation analysis under Rule 37E. Rule 37E does not define prejudice, but the advisory committee note explains that an evaluation of prejudice from the loss of information necessarily includes an evaluation of the information's importance in the litigation. Plaintiff contends that deleted communications may have further shown defendant's execution of the digital campaign, and thus severe prejudice is obvious because relevant communications were deleted, impairing her ability to fully prosecute her claims and rebut the defense that the strategy for a proactive digital campaign was abandoned because of organic flood of negative internet activity spawned by Lively's own conduct. Lively herself rebuffs the notion of prejudice on the very first page of her motion, admitting that despite defendants' efforts to cover their tracks, there is substantial evidence that the allegedly retaliatory digital campaign was implemented as planned. Lively fails to explain why, if she already has substantial evidence, the lack of further evidence prejudices her ability to prove her claim. In fact, district courts routinely exclude relevant evidence that is needlessly cumulative. Rule 37E1 authorizes an award of attorney's fees and costs to the moving party to the extent reasonably necessary to redress any prejudice caused by the spoliation. The purpose of this remedy is to ameliorate the economic prejudice imposed and also serve as a deterrent to future spoliation. As shown above, plaintiff fails to show that defendants, or any of them, violated Rule 37E, much less that she was prejudiced by a deletion of relevant signal messages. Accordingly, plaintiff is not entitled to reasonable attorney's fees to cure any imagined prejudice. E. Plaintiff fails to show that any defendant had a culpable state of mind when signal messages automatically deleted. As noted, Baldoni and Sauerwitz did not use Signal to communicate about the film prior to the filing of her December 2024 complaint, and therefore could not have deliberately deleted Signal chats. Abel used Signal prior to December 20th, 2024, but not to communicate about Lively. Nathan and Wallace routinely used Signal for the security it provides to protect sensitive crisis management communications for their high-profile clients. Plaintiff concedes that the Signal auto-delete feature was disabled after litigation commenced, and defendants have produced post-filing Signal messages. And we've got a footnote. Signal permits users to implement settings that cause messages to automatically delete on the devices of others with whom they are communicating. These facts weigh heavily against the notion that in using Signal and its auto-delete, defendants acted with culpable intent to delete relevant evidence. With respect to the Wayfarer defendants, the motion is silent on culpable intent, with Lively merely asking the court to extrapolate intent from the fact that the auto-delete feature was used. This is insufficient for Rule 37E sanctions. 4. Plaintiff fails to meet her burden under Rule 37E2 for the severe sanctions she seeks. Rule 37E2 provides for more severe sanctions, including an adverse inference and preclusion. Plaintiff seeks an adverse inference and preclusion order establishing that allegedly lost ESI was unfavorable to plaintiff and barring defendants from presenting any evidence to support their defense that the strategies set forth in the scenario planning document were never executed. Such an order, I love this line, such an order would conveniently relieve Lively of the burden of having to prove her claims with admissible evidence, something discovery has shown she cannot do. The more severe sanctions available only under Rule 37E2 require a showing that the spoliating party intended to deprive the moving party of information for use in the litigation. The intent standard for sanctions under Rule 37E2 is particularly harsh and stringent and specific. The moving party must show not merely the intent to perform an act that destroys ESI, but rather the intent to actually deprive another party of evidence. A showing of prejudice from the destruction of highly relevant or even dispositive evidence may be insufficient for Rule 37(e) sanctions, absent a show that the evidence was destroyed with the intent to deprive the moving party of its use in the litigation. An intent to deprive could be found either from a conscious act of destruction or a conscious dereliction of a known duty to preserve electronic data. The Second Circuit applies 4 factors to determine whether a party acted with the intent to deprive. 1. Evidence once existed that could fairly be supposed to have been material to the proof or defence of a claim at issue in the case. 2. The spoliating party engaged in an affirmative act causing the evidence to be lost. 3. The spoliating party did so while it knew or should have known of its duty to preserve the evidence. And 4. The affirmative act causing the loss cannot be credibly explained as not involving bad faith by the reason proffered by the spoliator. Plaintiff fails to meet any prong of the intent to deprive test. First, as shown in section 3c above, Lively fails to show that relevant evidence existed. At issue are signal chats between the Public Relations Crisis Management Team and all Wayfarer defendants in the pre-litigation period, August 2024 to December 20th, 2024, when Lively filed her complaint. At best, plaintiff proffers that at least some of the defendants used Signal to communicate about this case. Plaintiff only speculates that the deleted chats may have included evidence that defendants executed on a plan to manipulate internet traffic. Second, plaintiff does not show that defendants engaged in an affirmative act causing the evidence to be lost. As noted, Nathan, the primary user of Signal chats, routinely used the ephemeral messaging system, and there is no evidence that she deliberately set the auto-delete function for communications relating to Lively. As for the other defendants, they either did not use Signal prior to December 20th, 2024, or use Signal only for communications unrelated to Lively. Plaintiff presents no evidence to the contrary. Third, addressed in section 3b above, Lively fails to show that any defendant deleted relevant Signal chats knowing of a duty to preserve the evidence. The allegedly deleted Signal chats concerned the digital campaign and the public relations crisis management strategy developed in August 2024. Plaintiff makes no effort to show that defendants had notice of potential litigation relating to the digital campaign or public relations strategy. Finally, the use of auto-delete can be credibly explained. At the time the crisis management strategy was developed, the internet was already ablaze with stories about the Lively-Baldoni dispute, triggered primarily by Lively's conduct in excluding Baldoni from the marketing of the film and the premiere, Lively's unfollowing of Baldoni on social media, and Lively's own missteps in marketing the film. Surely even plaintiff would admit that keeping crisis management communications confidential and safe from hackers and aggressive media players can be credibly explained as not involving bad faith by the reason proffered by the spoliator. Plaintiff points to Barbara, which hardly advances her cause. There, the plaintiff deleted documents that would have shown when the plaintiff first discovered the infringement at issue in the lawsuit. Since the deleted documents included the plaintiff's initial correspondence informing his attorneys of that discovery, the deletion plainly arose in the anticipation of litigation. The court found that even though the documents were highly relevant to the defendant's statute of limitations defense, the plaintiff acted culpably in deleting the documents. The severe sanction of an adverse inference was not warranted because the defendant failed to show that the plaintiff deleted the documents to deprive defendant of the information's use in the litigation, as required under subsection E2. Other authority cited by plaintiff is also inapposite. In Federal Trade Commission versus Noland, the court imposed sanctions against defendants who, after they learned of a Federal Trade Commission investigation, installed an encrypted ephemeral messaging application to communicate about work-related items, turned on the auto-delete function, and ultimately deleted the application before turning over devices for forensic investigation. And in Herzog versus Art Foundation for Medcare, the court imposed sanctions where defendants switched to Signal mid-litigation and configured it to delete text messages was intentional and done in bad faith. These out-of-district cases involved circumstances in which the spoliation occurred during litigation or an active investigation, with the clear intent to evade discovery by destroying communications. In Oakley, the court found an intent to deprive the plaintiff of text messages where the defendant admitted knowledge of an obligation to preserve his text messages and still allowed text messages to be destroyed when he upgraded his phone. This is a far cry from the facts before this court where litigation had not commenced. It is unclear what relevant evidence, if any, may have been deleted and by whom, and whether any defendant anticipated litigation over a planned public relations campaign during a time Signal was set to auto-delete. For the foregoing reasons, defendants respectfully request that the court enter an order denying Lively's motion for Rule 37E sanctions in its entirety. So, that's that. Very good motion. Great response. There's a lot of points in there which I talked about, I think, when Lively, when I did my video on Lively's initial motion. Such as if the fact that, Lively herself acknowledged that Nathan and Wallace routinely use Signal as part of their work. And, I kind of covered, well, yeah, that makes complete sense. But also, that does not mean everyone else, she kind of alluded that the others did not routinely use Signal. But it would have made sense to me that taking on the crisis management, taking on both Tag and Street, if that's how they work, then they may have been, it may have been requested of Wayfarer to follow suit, to maintain that, security that they seek for their own businesses. That would not have been outside the realm, but what we've actually found out is most of Wayfarer did not even use Signal before she sent her, her cease and desist letter, which requested preservation of documents before she actually litigated anything. So, a lot of really good points. And again, the fact that she also tried to make a blanket request for sanctions to bar the testimony of all 8 defendants is just nuts. Really nuts. And I think that Ellen has done a great job of highlighting that. Like, no, you've got to be specific. Who deleted the evidence? What evidence? What did they delete? You need to say a bit more to get that level of sanctions. You can't just speculate it. And I think it's a really good job. Lively will get a right of reply, but I'm really pleased with this. I said this before. I've been burned by it as well. I can't see how Lyman can argue with what is being said here unless Lively comes with evidence of who did what. when, and how would it have affected her? How would it have prejudiced her? Like, if she's already got substantial evidence, then how would deleting these messages have, made her unable to litigate her claims? And unless she comes back with that in her reply, which I don't think she can, then I can't see how Lyman finds a way in this case to grant her request. I just don't see it. All right. I'm going to leave it here because I've still got to do the Stephanie Jones, Abel's opposition to Stephanie Jones's identical motion for spoliation sanctions. So I will be back later with that. I'm probably going to do the attachments tomorrow, I think, because I've not had breakfast or done anything yet, and I've done these 2 videos so far. My mouth is already feeling mushy. So I'm going to just do the next big memorandum, and then I'll probably leave it there for now. I might see how I feel a bit later on. Go out, enjoy the day, and then see how I feel. All right. Take care, everyone, and I will be back later.